Well, welcome everyone to the case study. Again, we want to remind everyone that this is an opportunity to be able to really put some lessons learned in place. And the whole thing that we're wanting to do is just really support you. It is unreal how many times we face the same problem on different projects. And so we're just trying to give you a boot up in order to take care of those issues when you see them arise. Now, today I'm really excited because I have an absolutely amazing guest, and Megan is going to be with us today talking about contracts. And so we're really lucky to have her. I'm pretty sure she's probably at that $550 an hour mark. So we're really fortunate to be able to have the contract coach with us today. Welcome, Megan.
Thank you so much for having me, Corey. And I just have to say, I love your background. It is
Oh.
so cool.
Thank you. I like the vintage look. It has lots of color, but I really appreciate that.
Yeah, it's awesome.
Well, tell us a little bit about yourself and how you got to be in these two male-dominated industries. One wasn't enough. So you wanted to jump right in and be a construction lawyer. So tell me more about how that happened.
Yeah, I know. I guess I'm just a glutton for punishment, right? It was actually it was a bit of an accident, but a happy one, of course. So I've been practicing law for about 15 years now, and like a lot of people, I think, especially my age, I went to law school because I was a big fan of Law and Order. I really liked Jack McCoy, and I wanted to be his like new ADA prosecuting criminal cases. And so when I was in law school in my first couple of years out of law school and practice, that was sort of what I did. Although I was a little bit more on the criminal defense side, I did a little bit of both. I dabbled in both, but probably a little more defense than prosecution. And unfortunately for me, I graduated law school in 2009, and we all sort of remember what the economy was doing in 2009. And so all of the district attorney's offices and public defender's offices here in California were on hiring freezes. And so I sort of had to pivot out of necessity. And so I decided to join a law firm doing civil litigation. And I was at one place before I joined my current firm. I joined this firm in 2012 when I was about a 2 or 3 year attorney. And when I started here at the firm, they had a much smaller construction practice than they have now. And it was sort of the new training ground for attorneys. So when new attorneys would join the firm, they would kind of inherit the construction practice because, as again I said, it was much smaller then. So when I was a new girl in town, came on board, they handed me the practice area, mostly representing a concrete subcontractor, and I got super lucky because that concrete company had hired a new general manager within a couple of months of when I got hired at the firm. And so he took over their managing their litigation portfolio. I took over handling their litigation portfolio at the firm. We kind of looked at each other and sort of said like, well, neither one of us really know what our predecessors were doing, why or how they were doing it. So let's make this what we want it to be. And it was an amazing experience because I discovered that I actually have a love for concrete that I never knew. I know it's so strange. I'm obsessed with concrete. I got to go to World of Concrete. It was like the best conference I've ever been to. I can't wait to go back again. And I sort of fell in love with the practice area. So I went to the partners at the firm at the time, probably about a year in, and I said, hey, like, I don't want you to pass this on to the next new hire. I want to own this practice area. I want to grow it. I want to bring in more construction clients, and I want to really grow this out and make it my own thing. And my partner now, the Radoslavich and Radoslavich Shapiro, he sort of pulled me aside and he said, okay, look, we really like you. We want to support you. But I'm just letting you know, some of the other partners here don't have a lot of respect for the area of construction law. The exact quote back then was, even a monkey could do it. And so we're going to support you and let you do this, but I'm just letting you know that some of the other this is going to be limiting your growth here because some of the other partners think that it means that you're kind of lazy and you don't want to be challenged. And I sort of laughed at that because it's like, I mean, especially now, 15 years in, looking back, it's just the absurdity of that position is just so laughable. But I sort of said, all right, well, it is what it is because this is what I want to do. So, of course, fast forward, and those partners' names are no longer on the wall. Mine is, and my practice is almost exclusively construction at this point, with the full support of Frank Radoslavich, the one who kind of said, we'll let you do what you want to do. So now I almost exclusively do construction law. I still do a lot of litigation, but a couple of years ago, I sort of realized looking at the litigation that my clients have had over the years, there were a lot of common threads that could have been managed better on the front end with a little bit of proactive risk management, particularly when it comes to the contract negotiations. And so I've incorporated in a lot more sort of proactive risk management, a lot more obviously contracts, negotiations, redlining, drafting, things like that. So I now sort of fashion myself as what I love to cheekily call outside in-house counsel. So I want to sort of be the one-stop shop for my construction clients for pretty much anything that they need, with the ultimate goal of keeping them out of litigation, but at a bare minimum, setting them up so that they will they'll have better outcomes if they do end up in litigation.
Well, Megan, I don't know if this is a good time to tell you this, but that's called working yourself out of a job. So
I know, right? And that's so funny because I've had clients actually kind of look at me, and I get it, right? Attorneys have the reputation that we have for a reason. So I've had clients that were newer clients to me that I hadn't yet earned their full trust yet, kind of look at me skeptically, like, that doesn't seem to make sense on paper. How is this ultimately going to end up screwing me over? And I'm like, I get it. But I would much rather take your dollars on the front end and help you not get into litigation, because there's going to be plenty of work for me to help you avoid litigation too. And I'd rather you not have to pay out the money to your insurance carrier for the claims and the deductibles. And I'd rather just help you prevent it in the first place. But yeah, you're right, Corey. It's probably not a smart business move.
Well, it is always a hard sell, right? Trying to convince people to pay money up front in order to save money on the back end when you don't really know how much that money is going to be. And I 110% agree with you about proactive and being proactive. And we do all have reputations, which is why I find it funny that you started in criminal law and then you moved to construction. So, it's like one of those things where I started in animal science and then I moved into construction. And for some reason, it just seems to fit. But,
yes.
It's really that opportunity to help our contractors make a higher profit in these really tight markets. And the complexity of these projects is just getting deeper and deeper. And so understanding contracts is going to be key. And I'm so excited that we get to talk about this today. But before we really move forward, I myself have a question. Do you stick mostly with subcontractors, or do you also support general contractors? And how does that dynamic work when you're doing your thing?
Yeah. So from the law firm standpoint, so I should clarify, I'm only licensed to practice law in California. So I only represent, as an attorney, construction companies that are in California. I can only give legal advice in California. So as an attorney, I kind of represent all the stakeholders. So I've had owners, I've had GCs, I've had design professionals, but the bulk of my clients are the trades. I sort of always say the trades will always have my heart, because as I said, I came into this through concrete. I met my husband this way. He was actually a superintendent working for one of my other trade contractor clients. So I sort of fell in love with construction law and then literally fell in love. So the trades will always have my heart. But similar to my love story, my husband actually joined the GC side just about a year ago. And on the consulting side, I have found that despite the fact that if anybody follows my messaging on LinkedIn, I tend to, from a messaging standpoint, be fairly pro trade contractor. Despite that messaging, I find that on the consulting side of things, on the construction contract coaching side, I'm actually attracting a lot more general contractors. And I love that fact, because the ones who seek me out and hire me in spite of my pro trade contractor messaging are the ones I want to work with, because they come to me and say, we picked you because we want to be better. We want to be the GC that does treat our trade partners like true partners. We want to treat them fairly. So we want the girl that only loves the trades to whip us into shape and tell us how to be better partners. So I do actually work a lot with GCs, but the GCs who have that mindset that I appreciate.
Yeah, no, I love that. And you're absolutely right, because that collaboration is what's going to really, really make the project set apart. So fantastic. So today we're going to talk about a challenge, and it's probably going to be a challenge that other people have faced, and they went about it a certain way in order to resolve it. A lot of times when we resolve things, we're just putting out the fire. We're just putting the Band-Aid on. We're not really taking care of it. And this is an opportunity for us to kind of reflect back and see what we did, what we did wrong, what we did right, and how would we have done it in the first place in order to be able to prevent it from happening altogether in that preventative way that you're talking about. So
Yeah.
can you share with us the challenge that you're going to talk about today?
Yeah. So, we didn't talk too much, but I didn't give you a peek behind the curtain of my thinking ahead of time. So hopefully
That's
you're not
okay.
like, what are you talking? What are you doing? This is not what I meant. But because I sort of identify as what I call construction adjacent, because I'm not, boots on the ground, I sort of was thinking through when you told me what we were going to be talking about. I was actually thinking about some of the problems that my construction clients face, because I think that
Yeah.
that's probably an archetype that's more helpful for most of the viewers and listeners, is not what challenges I've personally faced as a construction attorney, but more the ones that I've helped guide my construction clients through.
Yeah,
And so,
absolutely.
yeah, so and particularly thinking about when I was trying to decide which of these issues to talk about today, I really wanted to try to find one that could have had a different outcome had we approached it differently on the front end. And so, I sort of landed on one that involved it was a trade contractor. So I was representing one of the trade contractor clients, and I didn't get involved in this one until it was already in litigation. So for those of you who may not have actually been fortunate enough to be involved in litigation over a construction project, I'll just give you a little bit of a timeline. That happens way down the line. So we've got the bidding, we've got entering into the contracts, we've got actual construction, which of course, depending on the size of the project, can take years, particularly for commercial projects, which this was. And then oftentimes we've got completion, we've got occupancy, and the litigation doesn't result until even after occupancy, depending on what the nature of the dispute is. So in this particular case, it was a very large commercial project that did span several years of the actual construction phase. And the actual issue that became what blossomed into litigation was related to delay claims, but they didn't come until the project was almost complete, but not all the way complete. So we didn't yet have occupancy. We didn't have our certificates of occupancy. Many of the sort of finishing trades were not yet done with their scopes of work, and the litigation bubbled up and became active, which presents its own unique set of challenges when you are one of the trades that is still supposed to be performing, and simultaneously you've been brought into a lawsuit about the project. So there were a lot of really interesting dynamics in that one.
And I would say that one of those main dynamics is that there might have been some rough connection to that particular delay issue throughout the project, but no one truly thought to document it or create it as a pinpoint until they needed a scapegoat at the end of the project.
Yes. And, I think the thing, I've obviously handled a lot of delay claims over the years. Unfortunately, they're not uncommon.
No.
Usually we're able to resolve them short of full-blown litigation, thankfully. But I've handled dozens and dozens of delay claims over the years. What made this one stand out was the GC and all of the trade contractors were actually aligned in taking the position that the delays were actually caused by the owner and not any of the construction side of the project. And I think, thinking back, I think that's the only delay claim that I've been involved with where the GC and the trades were holding hands and were not pointing at each other at all, throwing each other under the bus at all. It was a united front pointing the finger back at the owner. And the underlying issue was extreme amounts of design changes, design changes. It was so bad that the position that ended up, this one went all the way through a conclusion. So there was an arbitration clause in the contract. So it wasn't in court. It was that sort of private trial for people who kind of think of arbitration as kind of a private trial. So it went all the way through the arbitration process. It was never able to resolve through settlement. It went all the way through. And the position that all of the construction side of that case took was that the owner actually used one set of plans to bid the project, knowing from the very beginning of the project that they intended to do so many design changes that they knew from the beginning they wanted a completely different building than what they bid, but they didn't want to pay for it. And so they did that through continuous design changes and then denying change orders that resulted from the changes in the project. And because of the denials for the change order requests, That caused the delays. Then we got into liquidated damages territory. Then those had to be pushed down from the GC to the trades because of the contract requirements. And it was just a complete mess. But like I said, I think that what makes that one stand out to me the most is that it's very rare, particularly in a delay type of claim, to see all of the construction parties sort of linking arms and making a united front against the owner.
Yeah. And so we've got an owner that the changes were desired, requested changes, not altercations or modifications to the drawings because of a misstep in the drawings themselves.
Yeah, that's exactly right. And I see in the comments somebody wanted me to clarify when I said extreme in quantity or complexity. And the answer to that and to what you said is both. The position that
we've got a 10% rule sometimes in construction, right? Anything that causes more than a monetary 10% change to the contract means that the contractors weren't able to bid it eggs to eggs or apples to apples. And so that monetary aspect can be seen as a way to show what extreme is on a project.
Yeah, exactly. And in this particular case, I think that the extremes in quantity and complexity, again, the position again that the construction parties took was that was the plan from the owner's perspective all along. And I remember there was a very striking visual that the general contractor's attorney created to use in the arbitration. And it was like the mock-up photo of the completed project from what was bid versus the mock-up photo of the completed project based off of all of the design changes. And I mean, when I tell you, if I showed you these two photos without telling you a story or giving you any context, you would not believe that this was the same building. It was that extreme. So that's what I mean quantity, because they did it slowly and incrementally so that the parties wouldn't pick up on what they were doing, but also in complexity because it was a completely different project at the end than what the parties bid at the beginning.
So herein lies your criminal background, where we have to decide if it's premeditated when they're going through and doing this, right?
Yep.
And so you're representing the owner in this case, the one that is being seen as the one at fault, let's say.
Okay.
But that's who you're representing.
Oh, no. In the actual case, I had one of the trades. I had one of the trade contractors.
Okay, perfect.
Yes, no, okay. I did not have the owner. I had one of the trades. Yeah, I had one of the trade contractors.
So you were on the right side of the coin.
Yes. And fortunately, I never, because I was representing one of the trade contractors and because I was just one of the attorneys involved, I never had to actually decide whether or not I thought that the owner had that sort of nefarious intent out of the gate. But the arbitrator did. It was an issue that the construction parties put in issue in the case, and the arbitrator did have to make that determination.
And so I can imagine that this is a huge challenge, but this is a after the facts challenge in reflection, where you're having to look back and try to do research, do discovery, trying to find things. And so how does the contract fit into this? How are you using the contract as a tool in order to be able to help support your trade contractor in this situation?
Yeah, so that was kind of the great lesson learned for me and for that particular trade contractor, because I'd never before been in a situation, and neither had the trade contractor, where the amount, and again, the extremity, both in quantity and complexity of the change of the design changes, could have been managed better based off of proactive contract negotiation on the front end. And so this case, it's been years and years and years since this case actually happened, but it's always one that I think of often, because looking back, I realized that both from a negotiation redlining standpoint when we were in the contract negotiation phase itself, but also from a contract management standpoint while the project was ongoing, there were a lot of things that we could have done better. Spoiler, the outcome, I think that I can't say too much because it was a private arbitration, but I believe, in my opinion, we got the right outcome. So I'll let people infer from that what they may based on who I represented and how I've characterized the dispute itself. I think we got the right outcome. But nevertheless, looking back, it was sort of like, okay, this was an expensive lesson to learn, right? Even though the outcome may have been what we felt like was the right outcome, they still had to pay me to fight the fight. And that's never cheap, right? So it was like, okay, what could we learn from how this went south to better help us manage the projects in real time when we're still on the job? And also, how can we, or can we, and if we can, how can we better redline the contracts on the front end to avoid putting ourselves in a position where a project can be changed so dramatically with such consequences to the schedule? And so those were the kind of two different buckets of lessons that we kind of learned that were that related to the contract.
Well, let's talk about that for a second, because if it was truly premeditated, then we could assume that maybe the owner had terms and conditions in the contract that were going to favor them making these changes, that would make it easy for them to make changes without thinking that the cost was going to come back on them. Or, you know, when we develop these contracts, a lot of times they're very onerous to whoever creates the contract, whether it's the general contractor or whether it's the owner. And so the pushback is, you know, I'm just a trade contractor. I just want the job, man. Just give me the job. And so when you talk about redlining something, it can be pretty intimidating in a competitive field where you don't want to lose this job, and you'll just take care of it once you sign the contract. So how are you now, in reflection and through your experience and working on that particular project and seeing that, how are you supporting your contractors and understanding how to really travel that delicate line?
Yeah, and unfortunately, that is something that I hear often from the trades, right? I mean, so many trade contractors either actually are in that position or fear that they are, and so they act as though they are, even if it maybe isn't true. What I mean by that is I've had some clients in the past who actually had a ton of power based off of their scope of work and the trade that they're performing and their relative lack of competitors in our region. So they had a lot more power than they thought they did, but it's still such an ingrained mindset for so many trades that they just need the work. They just got to make payroll. They just got to keep their guys busy, right? Like they don't have the power to negotiate. They don't have the power to walk away from a bad job or a bad contract. And so it's an objection that I deal with all the time still, unfortunately. And what I sort of try to tell people, especially so let me say this, it's easier to sell the trade contractors or the GCs too, because the same arguments apply for GCs negotiating prime contracts with owners too, right? So even though I'm talking mostly about the trades, it's the same regardless, whether you're the trades negotiating your subcontract or you're the GC negotiating your prime, the principles remain the same, which is if you've never been involved in an actual lawsuit, if you've never had a project that went so far south that you saw how bad it can go, then it's really hard to get them to understand the risk that they're truly taking, because they've been fortunate and they've never had to see the downside of it. That's the harder sell. The ones who've been unfortunate enough to have been involved when a project has gone very far south and lawyers have gotten involved and litigation has ensued, it's a little bit of an easier sell for them because they know what's at stake. But in any case, I often say to what I call the downstream party, so whether it's the trade contractor negotiating the subcontract or the GC negotiating the prime, whoever is the one that is in the position of receiving the contract from the other party who drafted it, I always sort of say to them, you know, when you're looking at this contract, imagine worst possible case scenario. Look at the overall, I call it the vibe check. Honestly, it's just sort of the vibe check, the overall vibe of the contract. When you read the whole thing from beginning to end, does it come across as feeling fair and balanced to to some extent, right? Like, is there some give and take? Or is it the upstream party is pushing every scintilla of risk down to you that they possibly can, and they're bearing no responsibility at all? What's the vibe check of the contract? And if it is that kind of contract where the upstream party is just pushing all of the risk onto you, heavy LDs, they're keeping their ability to deny additional time related to change orders. They'll consider a request for additional compensation, but they'll never give you additional time, no matter what the scope of the change is. Those types of really egregious terms, I sort of say, like, look, I get that you have this sort of scarcity mindset that you feel like you really need to sign this contract and take on this project. But if it goes south and it goes as bad as it can, is it really worth it? Because I've seen projects where the trade contractors or even the GCs, again, the downstream party, has ended up not only losing their entire profit margin on a project that went south, but they've actually had to pay out more than they ever received, more than their contract value was to begin with. So they've actually lost money on the job because it went south. And that's not good business for anybody. And so I try to get them to really sort of think about it like that. Also, from that vibe check of reviewing the contract, getting that feel for how the upstream party is going to treat you on the project. I mean, if you're looking at my pet peeve contractual provision that no one will ever convince me has any validity or merit to it, is what I call the cross default provision. What that is, if you don't know, is if you are entering into some sort of master agreement, if you're a trade contractor entering into like a master agreement with a GC, where you're going to be doing multiple jobs, mostly with multiple owners. And there is a provision in your subcontract that basically says, if you default on one project, we can withhold your payment on any other project that you have going with us.
Yeah.
It's abusive. There is no good faith basis for that type of provision. I rail against it all the time. And I tell every single one of my clients and anybody who will listen to me that that is not a contract you should sign ever under any circumstance, even if it means you're looking at how you're going to make payroll. I don't care. It is crazy risky and there's no good faith justification for it. But if you've got a contract,
I can't even see it being legal. I mean, it's unjust enrichment that you have just created on another project that you've completed with materials for that project. And even though it's an illegal clause that's in the contract, and even though you may win one day, like you said, it takes forever for these things to get through the court system. And by that time, you might have drained all your money from your company and have to shut your doors.
Yeah, exactly. And so, so what I will say is, if you've got a contract like that, I mean, it doesn't have to be that extreme, although I've been seeing those in more and more contracts. It's becoming standard, which is horrifying for our industry. I hate it. Which is again why I'm leading the charge on telling people to push back on it, because it's becoming more standard. But even if you don't have something that egregious, if you just have one of those contracts where the vibe check is sort of like, this is pretty unfair, this is pretty one-sided, this is pretty imbalanced. If they're already treating you like that in the beginning, at the negotiation phase, before you've even signed the contract and set foot on the job site, how are they going to treat you during the project when there are hiccups along the way? When you actually do have some issues that pop up and you need to be able to work together to resolve those issues, supply chain issues that are outside of everybody's control. You don't want the asshole GC on the other side that's giving you a hard time when it's outside of your control. You want the GC that's going to say, okay, I get it now. Let's work together to figure out how we can minimize and mitigate this risk to everybody so that the owner doesn't suffer on the back end, for example.
Yeah, no, I love that. And I 100% agree with that, and I tell people the other way, if you're a contractor and you can't provide a comprehensive, accurate schedule when you start the project, and you can't do it in Microsoft Project or something simple like that, what is the professionalism that you're going to carry for the rest of the project? I haven't even started asking you to do physical work yet. I just need a schedule from you. So and I love those contracts that the trade contractors are asked to sign with the general contractor that holds them liable to everything that the general contractor signs with the owner, but then doesn't give the trade contractor a copy of that contract.
Yes. And not only does it hold them to it, it has language in it that says you received a copy of the prime, even though they won't give it to you. It kills me.
So fantastic. We're going to take just a little break here because we have some great audience participation. And so I want to invite them to ask any questions that you might have right now. Go ahead and put them in those comments so that Megan can see what it is that you're looking for. This is a great opportunity to get some free legal advice, and always make sure that you look for Megan on LinkedIn through her newsletter. She does a great job of being of service, as well as understanding that we're all here to make a buck. And so it's important to be able to show off her services that she can use to be able to help support you and help you. So, Megan, we've kind of gone into a little bit of how we avoid this situation altogether. And that's by really, looking at those red lines. And we talked about some of that resistance that we get from contractors who are like, hey, look, I just want to make a buck. I'll manage the job tighter. I'll keep better documentation. They won't be able to really hurt me with this contract clause. And then we get into the project itself and recognize that, whoa, there was some bad intent here. There was some other ideas or another agenda that was going on when we entered in this. And I know one of the most common things that we have with a contract is the meeting of the minds. So when you are here in this type of situation where somebody is blatantly not following the contract or the intent of what the contract is, when you had a meeting of the minds, how do you prevent this from happening?
Gosh, if I had the answer to that one, Corey, I would be a billionaire. Honestly, I'd be on a yacht in a harbor somewhere.
Well, I want commission on it then, because
I know. If I figure it out, you'll be my first call. But no, I mean, I say this somewhat tongue in cheek, but truly, that is the impossible challenge. That's where the human factor comes in, right? Like, we think of contracts as these sort of like rote, very technical, especially because they are written in legal jargon and very legalese, and they seem like this sort of like very complex part of the overall project, right? It's like this one complex part of it. But at the end of the day, I think of the contract as setting the rules to the game, but you can't control whether the players cheat. And so there really is no way that I figured out. Again, if I do figure it out, you will be my first call. But I haven't figured out how to manage to the idea that people are unpredictable, and oftentimes they're going to act in their own self-interest. And the worst of us, or on our worst days maybe, are going to throw each other under the bus. It's just human nature. And so I don't know that there's necessarily anything that you can do to prevent that on the front end. That really comes more into play when you're figuring out this kind of triggers what I talk about. I talk about using the contract as a collaboration tool and a tool to manage the relationship from the beginning. And what I mean when I say that is the negotiation tactics that you use when you're going through the red lines and you're talking about what the ultimate form of the contract is going to look like can be a great opportunity to help shape what your relationship is going to be like with the upstream party throughout the rest of the project. And how you go about those conversations and negotiations can help lay the groundwork for a positive working relationship going forward, which can then hopefully minimize the likelihood that you're going to end up in a situation where human nature makes what could otherwise be a minor problem balloon into something that becomes a bigger problem. And so that's when I really like to look at the contract and less the contract itself and more, like I said, the conversations around the contract, the negotiation that goes into the contract as the best first tool to start crafting how that relationship will be on the project going forward.
Well, I know a lot of people probably like the idea of a template or a boilerplate contract that they can use over and over. What is your feeling on that?
I'm not opposed to that, and it's certainly a good cost-saving measure. The big, of course, asterisk, right? There's always caveat. It's always going to come down to the quality of the template that you're using. So I'm not opposed to templatized contracts as a concept. I just want to make sure that when you're doing it, you're using one that's been vetted, you're using one that you understand, and more importantly, if you're the upstream party who's using the templatized contract and giving it to your downstream party, even if it's your sub-tier subcontractor or anything like that, you need to be prepared to accept red lines, because again, this comes a little bit from my pro trade contractor bias, but I think it's a shitty position to take to say we don't accept red lines at all. I think that's to my point that the contract can be the first tool for laying the groundwork for the collaboration. That's not a good starting point to a working relationship. If you just say take it or leave it, we don't accept red lines. I don't like that policy. So if you're the upstream party giving the templatized contract, be prepared for some negotiation, be prepared for some red line requests, and consider each one of those in good faith, and be prepared to know if you're using a templatized contract, because I'm assuming if you're using a templatized contract, you're probably not talking to somebody like me every time it gets negotiated and signed, which is totally fine. But then you need to know enough about your own contract and your own risk tolerance as a company and your own goals to know how to negotiate the red line requests that you're receiving from your downstream party. And again, I'm totally fine with doing that as long as you're doing it that way. Do it, but do it responsibly.
Well, I mean, let's be honest that if it's a templatized contract, it's likely coming from a general to a trade person. And that trade person probably has an invoice with some exclusions and inclusions down on the bottom of the invoice that serves as a one-page contract. Make sure you attach this to whatever template that you have for me to sign, because these are my terms.
Yep.
I'm sure those make you cringe.
Yeah, that just gets a little bit tricky, because usually the templatized subcontract that you just signed usually has language that precludes any inconsistencies. So when your bid or whatever it is that has your T's and C's gets now attached as an exhibit and there's a conflict, now it's a fight, and fights are expensive. So I prefer to just minimize the fighting, because if you have to fight about it, you got to pay me to fight. So it's expensive to have to fight. And so I don't like that. The other thing to consider with templates is there are several different, I'll just call them vendors, that are accepted within the industry as, providers of these types of templates. And each one of them comes with their own slant. And so you can pick which template you want based on knowing how that works. So AIA is a very common template. Those are pretty pro-owner. Even if you're looking at a subcontract, they're still going to be pretty pro-owner, weirdly. I don't know how AIA manages to work in pro-owner terms into a subcontract, but they do. So AIA is going to be oftentimes pro-owner or pro-GC because it benefits the owner. AGC is, of course, going to be pro-general contractor. I prefer consensus docs because they tend to be the most balanced in my mind. They're not necessarily what I would say they're pro-trade, but they tend to be the most balanced on that vibe check. Consensus docs tend to be the most balanced. Those are the top three that I see as sort of the vendors of the templates. And so I prefer consensus docs for that reason.
So Megan, I mean, I don't know if you've ever listened to any of my case studies before, but I push, the use of artificial intelligence in the opportunity of being able to expedite work. I would not suggest it for contracts. What do you say?
Thank you. I've been getting this question for the last year, of course, as AI has become more prolific. But I think I'm not sure exactly when the article's coming out, but I was just interviewed for a Construction Dive article about the use of AI in construction contracts. And here's what I will say about the use of it. First of all, before I give you my answer, let me give you some background, because I think I want people to view my answer through that lens, okay? I am pro AI. I just want to be very clear about that. I like AI. I think it's a great tool. It's got its value. It's got its utility. And I myself am a somewhat prolific user of AI. That said, I have the paid version of ChatGPT. I've used Notebook LLM. I've used Claude. I've used Gemini. I've used a lot of different AI tools. I've even used some AI tools that are specific to attorneys. And by that, what I mean is you actually have to have a bar number to be able to even purchase these products, and they're ridiculously expensive. So I've used a lot of these tools. I also separately teach a construction law and contracts course for UC Davis. And as part of that, we give assignments to our students. And so I'm using AI all the time to catch cheaters, right? Because using AI to complete your homework is cheating. It's plagiarism. And so I'm plugging in their assignments to see what kind of outputs that the AI is giving us. So with that said, I have tried almost every single AI out there, and I have tested it from a contract drafting standpoint, a contract redlining standpoint, and even asked it to give me negotiation strategies for getting the red lines that I want to request accepted. I've tested them all to see if they are able to do this yet. Okay, that is my background. They're not, and that's the problem. And the reason I say that they're just not there yet. And because of the nuance that goes into contract drafting and particularly contract negotiating, I'm not sure, I don't know if they ever will be quite good enough. What I always say is the issue with using AI for construction contracts, and I'm not talking about all types of contracts. I haven't tested this with other contracts because I don't care about other contracts. I'm a construction girly, so I've only tested it with construction contracts. So when it comes to construction contracts, the problem is that you have to know enough to know when it's wrong. And the average user who's trying to avoid hiring somebody like me and save a buck, and I don't fault you for that. I really don't. I get it. Trying to save a buck, trying to save time even, right? You guys are busy. Save time from reading that 65-page contract. Save money from paying me to do it. I get it. The problem is the average user who's doing it that way doesn't know enough to realize when AI is wrong. And AI, when it comes to construction contracts, is wrong more than it's right. Mm-hmm. It's not always wrong. I'm not going to throw it completely under the bus. So it has value to somebody like me. And that's why I said I'm a user, right? It's got value for somebody like me because I can weed through and know when it's right and know when it's wrong. And so if you are a user who feels like you are confident enough in your own knowledge of construction contracts to know when it's right or wrong, then use it to save time. I have no problem with that. But if you're like most people, if you're like the average user who doesn't necessarily know enough to know when it's wrong, you're going to get yourself in trouble and you're going to end up in litigation. And then you're going to have to pay me anyway. And it would have been a heck of a lot cheaper to pay me to teach you how to read a contract than it will be to pay me to get you out of the lawsuit that results because you used AI. And that's my
no, I 100% agree. I love how you explained it, because it's not that you can't use AI with contracts. You just have to know how you're using it, because you can ask it to identify potential issues that it has with the contract and highlight some of those. And then your client can then bring those to you and go through those. And that will lead you and your legal mind into, well, if it says this, then it must also have this in the contract. Did AI catch that? How come you didn't bring that to my attention? And so 100%. Well, Megan, this has been an absolutely amazing discussion. I so appreciate it, because I know that you're also being mom today. And so we had to kind of do some scheduling around that, which I always appreciate, working moms. But you've got some other stuff going on. So you're doing a lot of work. So tell us a little bit about what's going on and where people can find you.
Yeah, absolutely. So you mentioned it earlier, but I do post almost daily on LinkedIn, and they are almost always construction contract tips, whether that's clauses to look out for, potential red lines, even negotiation strategies. Again, I do tend to post from a pro trade contractor standpoint, but if you look at the actual content of what I'm posting from the perspective of just being the downstream contractor, then if you're a GC, you might get some value out of that too. So I certainly recommend following me on LinkedIn. I'm just at Construction Contract Coach. That's the same handle on all social media. I'm on LinkedIn, I'm on Instagram, I'm on TikTok, and I'm on YouTube. So you can follow me on any of those platforms, but I definitely post mostly on LinkedIn. There's far more content on LinkedIn than anywhere else. I also have a weekly newsletter that sort of compiles together all of the weekly posts called Construction Contracts Insider. It used to be Construction Risk Rewind. But I rebranded last year, and you think I know the new name by now, but it's called Construction Contracts Insider. And you can subscribe to that on LinkedIn, or you can also subscribe to that by going to my website. You can find me at meganshapiro.com. I also have a lot of other websites, but all of them can be found at meganshapiro.com. I also have constructioncontractcoach.com if you are interested in learning more about my contract coaching services. I've got doitlikealawyer.com if you're looking for some sort of mentorship as a woman in a male-dominated industry, construction law or otherwise. And then I've got convergeconstructionsummit.com, which is the home of the website and all information related to my construction industry conference that I started 2 years ago now. We will be having our 3rd annual meeting coming up in June in Chicago. The wait list is available to sign up to get updates on the progress of that. I have not yet released tickets, but the dates have been announced. It will be June 3rd through 5th in Chicago. I'm hoping that you will get to join us this year, Corey. You haven't been able to make it to the first 2, but I'm hoping Chicago will be our year that you are able to join us in Chicago. But so those are some of the things that I've got going on and some of the places that you can find me.
Well, I appreciate it. And I know that you are looking for sponsorships for that summit, and that's always very important to be able to get those people who support what you believe in. And obviously there's a big reason to be able to support what it is that you're doing, because you're helping a lot of people. And I appreciate you helping our audience today, being able to learn a little bit more about construction and construction law. So thank you so much for being here today, Megan.
Yes, thank you so much for having me. I really appreciate it.
Yeah, absolutely. And thank you also for talking about my women's retreat this coming Saturday. So you put it in your newsletter for me. So I appreciate it. We got a good crowd of ladies coming. So thank you.
Absolutely.
I also just want